So of course a lot of people right now are talking about Kyle Rittenhouse and how he got off on self-defense. But what they're not talking about is someone else who got off on self-defense the very same day. And that is Andrew Coffey. A SWAT team broke into his home and he got into a firefight with them and they killed his girlfriend. However, this was deemed self-defense, very similar to the Kenneth Walker case, another black man. But the reason so many people are ignoring this case, this guy getting off scot-free for killing a cop, is because it doesn't fit the racial narrative that they're spreading about Kyle Rittenhouse.
If Kyle Rittenhouse was black, things would have turned out way different. He probably wouldn't have even survived that night.
Well, clearly you're wrong because we can look at anecdotes and also statistics and both of them prove you wrong. This guy was severely disgusted because his lies he spread about Kyle Rittenhouse and the case did not work. Let's go over some in this video and another video.
He said that the two people that Kyle shot cannot be referred to as victims because that is a loaded term. He instructed the lawyers to refer to them as arsonists, rioters, and looters.
So this is a half-truth at best. He said they couldn't be referred to as victims because the entire case was whether or not they're victims. It's literally a murder case. That's how they work, and that's how the judge held every single case prior to that. But he never instructed anyone to refer to them as rioters or looters. He said they could refer to them as those things if they provided evidence. Just like they could be referred to as victims if that evidence was provided, which is what the entire case was about. But the prosecution already conceded that they were rioters, looters, and arsonists. So yes, the defense was free to refer to them as those things.
The judge would have let the jury see the picture of him underage in a bar with his bros, flashing gang signs in a free as F shirt.
He was not underage in a bar, he had just turned 18 2 days prior. And in Wisconsin, you can be 18 in a bar with a legal guardian, which he was with his mom. And he was not flashing gang signs, that's a lie. If that is a gang sign, then Biden did the same thing. Multiple times. But why would the judge let this stuff be shown in court? It's not even relevant to the case. It's a completely different situation. The situation was about whether or not he acted in self-defense.
The judge would have let the jury see the video of Kyle wishing he had his AR so he could shoot people in a store that was taken just 2 weeks before Kenosha.
Well, yeah, that's the thing. It was taken 2 weeks before. So it doesn't matter. It was an entirely different situation. Please learn how the law works. There was a video of Kyle watching people raid a store, not just people in a store. They were looting it and rioting. And he said he wished he had his gun. You can debate on whether or not that was a good thing to say, but it's entirely irrelevant because it was a different situation. Court cases are about the facts and the situation. They're not about random slander.
The judge wouldn't have dropped the illegal weapon charge based on a ridiculous loophole that said if his gun had actually been a little shorter, then it would have been illegal.
Yeah, I agree with you. The ATF is terrible at setting gun regulations. Glad that's one thing we can agree on. However, I think we should do away with all of them, and that's probably not what you think.
Some people think our justice system is broken, but this trial proves that it is working exactly how it was designed.
Was it designed to let black guys off killing cops? I mean, I'm glad this guy got off, but are you?